Welcome to News Hour by DLC, your one-stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in-depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 13th May 2025 and we bring you news that matters. The first news for today is as follows. On the 13th of May 2025, Chief Justice of India Sanjeev Khanna delivered a poignant farewell address, emphasizing that public trust in the judiciary must be earned through consistent integrity and transparency. He highlighted the judiciary's role as a guardian of constitutional values and fundamental rights, asserting that its legitimacy stems from public confidence rather than authority. During the ceremonial proceedings, Attorney General R. Venkatramani lauded CJI Khanna for his clarity in Ajmain's and commitment to upholding liberties. Solicitor General Tushar Mehta remarked that Justice Khanna's tenure would have made his uncle the late Justice H.R. Khanna proud. Senior advocate Kapil Sibal praised his encouragement of young advocates and his embodiment of judicial excellence. CJI Khanna reaffirmed his dedication to judicial independence by announcing he would not accept any post-retirement positions. He also acknowledged the bar's role as the conscience keeper of the bench, underscoring the collaborative nature of the legal system. Justice Khanna's tenure was marked by efforts to make the judiciary more accessible and user-friendly, focusing on reducing case backlogs and simplifying legal procedures. He advocated for a self-evaluative approach within the judiciary, responsive to public feedback, to enhance accountability and efficiency. As he steps down, Justice Khanna leaves behind a legacy of humility, principled leadership, and a steadfast commitment to upholding the Constitution and serving the public. Next news, Centre withdraws blocking order against 4 p.m. News, YouTube channel. Supreme Court informed. On the 13th of May 2025, the Supreme Court was informed that the central government has withdrawn its blocking order against the 4 p.m. News YouTube channel. Senior advocate Kapil Sibal, representing the channel's editor Sanjay Sharma, conveyed this development to the bench comprising Justices B.R. Gavai and A.G. Masi. Despite the channel's restoration, the Supreme Court has decided to keep the petition active to examine the broader legal issues surrounding the information technology, procedure and safeguards for blocking for access of information by public, Rules 2009. Justice Gavai noted that while the immediate relief sought has become infructuous, the case remains significant for academic and legal scrutiny. Sanjay Sharma's petition challenges the constitutionality of the blocking action, arguing it was executed without prior notice or a hearing, thereby violating his fundamental right to freedom of speech and expression under Article 19(1) or the Constitution. The petition also questions the legality of the IT blocking rules 2009, particularly Rules 8, 9, and 16, advocating for greater transparency and procedural fairness in content regulation. This case underscores ongoing debates about digital censorship, intermediary liability, and the balance between national security and free expression in India's digital landscape. Next news, Supreme Court issues notice over alleged illegal demolition of Waqf Dargah In on the 13th of May 2025, the Supreme Court issued notices to top UND officials in response to a contempt petition alleging the unlawful demolition of the Hazrat Kamal Shah Dargah, a registered Waqf property in Din. The bench, comprising Justices B.R. Gawai and A.G. Masi, directed the notices to Chief Secretary Anand Bardan, District Magistrate Savan Bansal, City Magistrate Pratyush Singh and Municipal Commissioner Namami Bansal. The petitioner, represented by Senior Advocate Kapil Sibal, contends that the demolition occurred on the night of April 25 to 26, 2025, without prior notice, violating an undertaking given by Solicitor General Tushar Mehta on April 17. In that undertaking, the Union assured the court that no Waqf property's character or status would be altered pending hearings on challenges to the Waqf Amendment Act, 2025. The Dargah, registered as a Waqf in 1982, and officially notified in 1986, was reportedly demolished, based on a complaint filed through the Chief Minister's portal, alleging it was an unauthorized structure. The petitioner argues that this action contravenes the Supreme Court's November 2024 ruling, which mandates prior notice before any demolition, allowing at least 15 days for response. This case is now tagged with a series of petitions challenging the constitutionality of the Waqf Amendment Act, 2025, which has faced criticism for allegedly undermining protections for Muslim religious endowments. The Supreme Court's notice signals serious considerations or the alleged breach of its earlier directive and the broader implications for Waqf properties nationwide. Next news: Supreme Court deems NIA's allegations of terror financing in Mundra Port heroin seizure as premature. On the 13th of May 2025, the Supreme Court addressed the case concerning the 2021 seizure of approximately 2,988 kilograms of heroin at Mundra Port, Gujarat. The National Investigation Agency, NIA, had alleged that the proceeds from this drug trafficking operation were intended to finance the Pakistan-based terrorist organization Lashkar-e-Taiba (LET). A bench comprising Justices Suryakant and N.K. Singh found the NIA's allegations premature and speculative, stating there was no compelling reason to currently link the appellant to prescribed terrorist organizations. The court emphasized that any such grave allegations require a clear and compelling evidentiary foundation, which can only be established after substantial evidence is presented by both parties. Despite rejecting the bail plea of the accused, Harpreet Singh Talwar, also known as Kabir Talwar, the court granted him the liberty to reapply for bail after 6 months, or upon significant advancement in the trial, whichever occurs earlier. The NIA's case involves the alleged international trafficking of heroin disguised as legal imports, such as semi-processed talc stones and bituminous coal, routed from Afghanistan through Iran and Pakistan to India. The agency claims that this operation was orchestrated with the assistance of the Inter-Services Intelligence (ISI) and Iranian intermediaries, aiming to generate funds for LET. This ruling underscores the Supreme Court's insistence on substantive evidence before attributing terrorism-related charges, particularly in complex cases involving international drug trafficking and alleged terror financing. Next news: Patna High Court affirms salary grants for private college teachers appointed before April 2007. On the 13th of May 2025, the Patna High Court ruled that all teachers appointed before April 19, 2007, in Bihar's private degree colleges are entitled to receive salary grants from the state government. This entitlement applies regardless of whether their institutions were funded through deficit grants or performance-based grants. A division bench comprising Acting Chief Justice Ashutosh Kumar and Justice Partha Sarthi criticized the state's attempt to limit benefits solely to teachers in performance grant-funded colleges, deeming such distinctions illusory and iniquitous. The court emphasized that the 2015 amendment to the Bihar Universities Act, 1976, extended coverage to all teachers appointed prior to the specified date. The court mandated the state to release the necessary grants to the respective universities within 3 months. These funds are to be used for disbursing salaries and allowances to the eligible teachers. Additionally, the court clarified that retired teachers are entitled to receive their due pensionary benefits in accordance with the University Grants Commission (UGC) pay scale. This decision arose from 2 letters patent appeals linked to earlier writ petitions filed by teachers seeking state funding for their salaries. Despite favorable initial judgments, the state had not implemented them. The 2015 amendment to Section 57 of the Bihar Universities Act introduced a mechanism for regularizing appointments made before April 19, 2007, even if they lacked prior approval from the Bihar College Service Commission provided they met the qualifications in Force 80D Dimime appointment. The ruling is expected to benefit numerous educators across Bihar, ensuring financial support and recognition for their services. Next news, Punjab Haryana High Court directs petitioner to challenge IB rules in plea against BCI fees. On the 13th of May 2025, the Punjab and Haryana High Court addressed a public interest litigation filed by advocate Tushar Tanwar, challenging the fees levied by the Bar Council or India BCI for the All India Bar Examination (IB). The petitioner contended that the BCI's charges 3,500 rupees for general OBC candidates and 2,500 rupees for SC, ST candidates lack statutory backing under Section 24(1)(f) or the Advocates Act, 1961, and infringe upon Articles 14 and 19, 1(g) or the Constitution. A division bench comprising Chief Justice Sheel Nagu and Justice Sumit Goel observed that to effectively address the grievance, the petitioner must directly challenge the examination rules established by the BCI. The court emphasized that under Section 24 of the Advocates Act, admission to the state roll is subject to the provisions of the Act and the rules made thereunder. Consequently, the petitioner withdrew the current plea with liber to file a fresh petition specifically challenging the examination rules. This development follows the Supreme Court's judgment in Gaurav Kumar v. Union of India, where it was held that enrollment fees cannot exceed 750 rupees for general category advocates and 125 rupees for SC, ST categories. The court clarified that any amount collected as a precondition for enrollment qualifies as an enrollment fee and must adhere to the limits specified in Section 24(1)(f) or the Advocates Act. The Punjab and Haryana High Court's directive underscores the necessity of challenging the specific rules governing the IB to seek judicial redress regarding the examination fees imposed by the BCI. And the final news for today is as follows. Na High Court seeks Centre's response on actress Rania Rao's Kofiposa detention challenge. On the 13th of May 2025, the Na High Court directed the central government to respond within 2 weeks to a petition filed by the mother of Kannada actress Harshavardhini Rania Rao. The petition challenges Rao's preventive detention under the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, Kofiposa, alleging it to be illegal and void from the outset. Rania Rao was arrested on the 3rd of March 2025 at Kempegowda International Airport in Bengaluru by the Directorate of Revenue Intelligence (DRI) for allegedly smuggling 14.2 kilograms of gold from Dubai. Subsequent searches reportedly uncovered additional gold, jewelry, and Indian currency at her residence. The petition contends that the detention order, issued on April 22 and served on April 23, was executed without providing Rao with the grounds for detention or the supporting documents, thereby violating Article 22 of the Indian Constitution. It also alleges that the detention order demonstrates a lack of application of mind, as it fails to specify the basis for detaining Rao under Section 3(1) or the Kofiposa Act. During the hearing, Deputy Solicitor General H. Shanti Bhushan, representing the Union or India, requested 4 weeks to file objections. However, the court granted only 2 weeks, acknowledging the petitioner's concern over the ongoing detention. The matter is scheduled for further hearing on the 3rd of June. Thanks for listening and consider subscribing to the channel. Well, that's all for today. Keep listening to Legal News by DLC.